Okay, if I did this right, we are live on YouTube. We are live on Rumble. We are live on Locals. And pretty soon the conversations are going to get incredibly hectic. It's going to be a full house again. I'm literally running out of slots, and I'll have to figure out how to arrange things. It's a good problem to have, but I always feel bad when somebody can't make it to the show. Andrea, I think, is going to be cutting out early. She has actual legal business to do. So I'm going to start with her because of the Brian Kohberger case. And I guess my main question is, are we looking at another Richard Jewell?
Great question. I mean, that certainly comes to mind. One of the concerns, of course, with that comparison is that Richard Jewell, that appeared to be a somewhat deliberate and malicious effort on the part of law enforcement to really pin it on him. Don't know if it's that or if it's just a situation where, it looks like police may have developed tunnel vision in their development of a suspect and hoped that it was going to lead them somewhere that it appears not to have panned out the way that they've hoped. But that would be certainly very deeply concerning if that were the case.
So what's going on? Can you break it down? Because from what I'm hearing, the reports of evidence that have been in the press have been, well, to say exaggerated would be a fair statement.
I think that would be understating it. At the hearing on the gag order a few weeks back, Jay Logsdon specifically talked about lies in the press. I mean, things that just have absolutely no foundation in reality being part of the concern and the driving motivation for having a gag order in this case. The defense has now filed some documents where they are essentially doubling down on that characterization. They have indicated that the state has, first off, no evidence of any of the victim's DNA in any of the places that they've searched associated with Brian Kohberger, most significantly in his car. No trace of victim DNA in his car, which is a massive blow from my perspective to the state's theory of how these murders were committed. And as well, no indication of any connection to any of the victims. This is directly contrary to a lot of reports that have been out there that, there was Instagram communication or that he had the victims' IDs, were recovered during the search in Pennsylvania. So a lot of that type of reporting is based on this filing really being significantly undermined.
Question on the car too, though. Wasn't it not only no evidence of DNA, but also no effort to clean the car in any way could be shown?
That's what I can infer from the statement. The specific statement the defense made was no explanation for the lack of DNA, and the evidence of cleaning would be an explanation for why there's no DNA there. So I think reading between the lines, that is what the defense is telling you. They did not find bleach. They did not find the carpets taken up for cleaning. They did not find white marks, nothing like that.
So what evidence is there?
Well, there is the circumstantial evidence of the touch DNA that was found on the knife sheath that has been matched to Brian Kohberger, or to officially at this point, it was matched to the sample that was taken from his parents' house and confirmed that the parents' house trash was probably the father of the person on the knife sheath. And they have some pings that have some indications of ability to reliably corroborate the movements that they're looking for, and others that appear to substantially undermine the movements that they're trying to attribute to him. Big questions of scale here. The police were able to trace the vehicle over, about approximately 75-mile trip, which is about how far it is between Pullman, Washington, and Clarkston, Washington. But when it comes down to the nitty gritty details of like, can you place him at this King Road home in Moscow, Idaho? It appears that their ability to be that precise is not particularly good. They've indicated in their own probable cause affidavit that on a couple of occasions, his phone had pinged off of these King Road cell towers, but they have knowledge that he wasn't there at the time. So just, questionable ability to really be able to employ these methods in a reliable way.
This is kind of the worst nightmare too, right? Because if it was, let's say, a serial killing case, then the argument like Son of Sam or others could be, well, guess what? The killing stopped. Well, this was a one incident thing where the entire act was a completion closer to, I guess, the actual Amityville horror than a serial killer. So that's even problematic because you can't say, well, the killing stopped. Well, they were already stopped. So,
yeah.
Who else? I know you guys all have questions that are smarter than mine.
I have a question. I'd really like to know. So I watched you on Ricada, and I learned a lot of things. I had been believing a lot of the rumors, like the ID cards were found and etc. And I was glad to, be rid of that myth. But the one thing that I remember reading that seemed convincing at the time was that he had apparently gone to the location of the house and was supposedly stalking them, or they could track his phone or track activity on his phone like 12 different times. Was that something that was also dispelled, or can that be?
Well, so this is coming from the probable cause affidavit, and this is based on that ping data. They're basically saying they can place him in this area on multiple occasions in the months leading up to these murders. But again, that just becomes a question of precision. It's not unusual to go between Moscow and Pullman. It's fairly common. They're very close together, both university towns and all that. So no, they have not particularly placed him, from my perspective, at the residence.
Right.
They can, potentially place him in Pullman or place him in Moscow. But again, this is just part of the technological issue that the defense is going to be looking at with these pings and the degree of precision they can attribute to any of this information. If these Moscow towers, if the range extend all the way out to Pullman, then it's entirely possible, that you're sitting on your phone in your own apartment, and for a variety of reasons, cell phone traffic, weather, service on towers, all kinds of things can cause you to kick over to one of these other towers that might provide coverage. So it's not necessarily an indication of any type of travel at all, unless they can use other methods to pretty specifically triangulate him or locate GPS data that can locate him a little bit more specifically. Then
if it's a smartphone and it was compensated, then it should have location services on the phone.
You would
and the
expect
fact that they're so weak on that kind of makes me question things.
Well, now this is information that they would have obtained his cell phone after his arrest, and whatever they were able to obtain from that search would have been after this gag order was put in place. Now, that said, obviously this gag order has not prevented a large amount of, at least speculative information being put out there anyway from anonymous law enforcement sources. But it just seems kind of hard to believe that, given that context, if they had found, something really significant like that would not have leaked.
Debbie O, I guess, has a family member who traveled the same thing, and this is pretty common.
Yeah, very common. Very common.
That was the weakest part.
Did you go over at all the motion for a protective order that the state filed?
Yeah, the one
I don't know if we talked about it before I got on, but
with the genetic genealogy.
Yeah, I thought that was really kind of, what don't they want the defense to have access to?
Well, I was going to actually ask you about that. Those labs, apparently there's labs that they aren't disclosing where they sent the stuff off to. Does the defense have any suspicion, they think, where they may have gone to, and if those labs have any particular issues, or is that just, they just know that they aren't being given the information?
Yeah, I'm not sure exactly how much the defense knows on that question. They are presenting this issue as one of transparency of the investigation. It's critical to know if the police followed leads to the conclusion that it was Brian Kohberger, or hit on Brian Kohberger as a potential suspect and then engineered, evidence like unreliable pings and stuff like that to do what they can to tie him to that connection. So that's an important question the defense is asking. We do know that Idaho has a contract with this particular private lab called Othram. Othrum's been involved in a lot of cold case investigations, and they provide these types of services where they will develop the type of DNA profile. It's a different type of DNA profile that they use for this genetic research than when they're just doing ordinary identification types of activities. So the state labs don't have the capacity to do this. Othram will develop that profile and then basically, submit it, go through this process of genealogical research to build out the family tree. We have reason to believe it's probably Othram in this case. We know, obviously, the genetic genealogy was used. The state is now conceding that. We just don't know when and where and how and all of that.
Wow. It's going to be a very interesting case. I've been looking at it, and it's going to be a very... Do we have a trial? Do we have any idea of when this is going to trial?
Well, so it's currently set for trial on October 7th. Brian Kohberger did not waive his right to a speedy trial. So it's, up in the air at this point, from my perspective, if it's going to go forward then or if it's not. There's kind of reasons to see it on both sides. The more that you let a case like this go on, the more that the state is potentially going to be able to dig up more and more remote connections or character smears or anything like that they can use to try to build this circumstantial case against Brian. So obviously by going sooner, you cut that sort of thing off at the knees. But of course, they need to be adequately prepared to be able to challenge the stuff that the state has, to be able to do their own investigation. We've seen, for example, they requested a delay in filing any kind of alibi defense. The way that the Idaho rules work is that if a defendant is going to rely on an alibi at trial, they have to disclose, where they say they were at the time and any witnesses that they intend to call to support that. And so in this particular case, of course, there could be witnesses from, the people that did the cell phone forensics for the FBI, the people that reviewed the video footage and stuff like that. If there are things like that in the state's discovery that can potentially help him, well, he's going to want to use those as witnesses. But you also have to have thoroughly gone through this 51 terabytes of data and 30,000 images and 30,000 pages of reports and stuff like that to be able to nail all that down. So it's just a massive preparation job for a trial like this. Raises some questions about whether October is really feasible.
What's your personal feeling on this? Because you've been covering this for a while. I mean, did you always suspect there was something wrong, or did this blindside you when all of this came in recently?
So when this first happened, when we got the arrest and the probable cause affidavit, my initial reaction is, okay, there's something here. There's enough to charge him. But a lot of this it's really just starting. The investigation is just starting. And so a lot of this stuff that they were going to get access to was going to be make it or break it for the case. The access to the vehicle is huge. Access to his phone and to his, devices, his computers and stuff like that. That's going to be huge. It's just, those types of fingerprints in a case are very, very hard to eliminate. And so all it was going to take was just a tiny little speck of the victim DNA in his apartment or in his car or something like that. Then he's looking pretty toast from a prosecution standpoint. And so it really is kind of, in that sense, I don't think anyone expected that it was going to apparently come out as empty as it has.
And he looks like a creep too.
I was just wondering if the pressure that was placed on the police, the investigators, I remember all that pressure. Why aren't they saying anything? Why aren't they, what's going on? Are they, just not investigating this? If that had a lot of play into, we got to finger somebody.
Yeah. Yeah, I mean, you have to assume that there's motivation with a crime like this, and the concern that there is, about catching the person who did it. There's an enormous amount of pressure to solve it. I mean, even from my perspective, 6 weeks was not a crazy long time for an investigation like this to be able to focus in on somebody and produce an arrest. But you're just looking at the coverage of it over that time period. I think the expectations were for a very quick and easy answer. And then when that didn't happen, just a lot of concern about whether it was going to be solved at all. So,
okay, what the part that I find that troubles me more than anything is people trying to make hay out of his stealing his sister's cell phone or whatever in 2014, which seems to be so what? I mean, like so far apart of
I'm
that.
sure
It's
he
like,
made fun of somebody in the 5th grade as well.
right, but am I wrong to say when you start throwing crap like that out there, then that's saying you really are desperate? It's like you're going to go from a domestic dispute or whatever and having a drug problem and I guess needing drug money or whatever the reason was to committing this horrendous crime. I mean, that's that's not a slippery slope. That's like Mount Everest.
Yeah, I mean, it seems like quite a bit of a reach to me. And this is exactly what I'm talking about when I'm saying if they aren't able to come up with a more direct tie between him and the victims, him and this crime, then it's likely they're going to go down this character assassination road. They're going to try to bring up whatever sort of prior bad acts evidence they can come up with. For two purposes. I mean, one, the remote possibility that this would be found relevant at trial and able to be used. I suppose a theft of a cell phone would be a crime of dishonesty, so they would be able to bring it up to impeach him if he chose to testify. I don't know if it led to a conviction. If it was just an arrest, it probably wouldn't. But I think the more concerning aspect of it, again, is just this tailoring of the narrative in the media, this persistent drumbeat of Brian Kohberger is a bad guy. He's a creepy guy. He's a scary guy. This effort to really taint perception and create this bias against him that, well, if he did these other things, then he's clearly the type of bad guy that would commit this type of crime. Seems like an enormous reach to me to go from a cell phone theft to a quadruple stabbing murders. But if the state doesn't have anything, better to work with, then they're just going to use what they can find.
Well, I think at the time with the probable cause affidavit, I remember reading it and I remember thinking it was very convincing and wanting to wait to see what the search warrants would uncover. But there was a very big deal made about the fact that, he was a criminology student and that would give him opportunity to study other serial killers, and that perhaps if he had the, predisposition, the inclination to want to kill people himself, that he could learn how to not get caught. And that with him having the white Elantra, I think those were like the two things that made him suspect number one. But everything from that seemed to kind of get smaller and smaller, like, oh, he has bushy eyebrows, and then the roommate who did not call 911 for 8 hours described seeing bushy eyebrows. Like
he doesn't have bushy eyebrows though.
They don't look particularly bushy. I mean,
they're not that bushy.
To say.
So I just feel like it's gotten smaller and smaller, like the the little thing. And then his sister's cell phone was like the ultimate, like, okay, like eye roll moment of what are we reaching for here? He's a vegan. He eats. He asked his aunts for new pans and pots. Like that doesn't make a serial killer. That just means he's an eclectic stranger. He's not.
Yeah, and that's when you asked me up front, Eric, is this a situation like Richard Jewell? That's definitely one way to look at it. But another way to look at it is it's maybe like Amanda Knox, the situation where you just don't like how somebody is reacting. You don't think they look right. He's got this weird background, that type of thing. And those types of perceptions and just stereotypes, frankly, that can color how people view a situation like this.
Right. And to the chat, when I said he looks like a creep, part of it is he's being framed like a creep. If you look at the angle of every photograph, he looks like Ted Bundy. You could draw a parallel between the two with the way they display it. It's always, he's kind of doing this tilt, and now he's just moving. You could choose any photograph you want. but they are definitely framing him up to where it's easy to visualize. That's all I'm saying.
Well, this is one thing. This is why I always say whenever I do the trial streams or I talk about all the pre-trial stuff, I say, look, if it doesn't come up in court in evidence, it never happened. Whether it happened or not, it didn't happen unless it's evidence in court. So I just wish the whole true crime genre and things would just go away, but it never will. It just keeps feeding itself and getting worse and worse to where the point is you're like, oh, but did you know he stole his sister's
Blind
cell phone
moms
when he was
must
14?
be satiated.
Oh, my favorite thing was somebody who said, oh, have you seen, well, something that happened in court, Jeff, is that apparently he has a really smug look on his face where he looks really satisfied with himself. And that means that and everybody in the comments is like, I've noticed that. That means he must be, oh, I'm so sick by it. It's something.
Now, don't tell any of your other previous guests, Eric, but body language experts is just beside witchcraft.
Yeah, okay, I'm going to pivot to that because I have a lot of body language experts on, and who I am friends with them. I'm not going to, but I also have had Eldred Vray on, who's a top deception expert in the world who doesn't like body language. So guess what? Yeah. I can do two things at once. However,
that's the one thing you can use body. I don't want to jump ahead. You can use your body language to influence other people, but to look at someone else's body language and extrapolate from it, it's just witchcraft.
Jeff,
I'm going to disagree. Hold on, I'm going to push.
Okay.
Because you're going at it. I'll be happy to put you on any stream with them, and you can compete it out, because some of what you're saying is true. You can take it to a witchcraft level and it can be bullshit. But you can also say, this person looks angry. Get out of the way. And don't tell me you don't do that. We read body language every day of the week, and it's 100% legitimate. Don't tell me you don't have people who are helping you lawyers out to pick juries. What are they doing when you are doing voir dire? They are looking at this, and guess what? It does work. So there's a problem with it. It is not a science. It's a pseudoscience. I'll say that all day. I have no problem saying that. And it is more of an art than an actual science. But when you're talking to people like Greg Hartley, who I've had on, who was a military interrogator for 20 plus years, they do know what they're doing. These are not the normal run of the mill. I read a book and I'm going on YouTube.
Well, and to be fair, there was something that I remember somebody on the behavior panel saying in a video a while ago that really resonated with me. We've been reading body language since before verbal language occurred.
Yes.
So in our little lizard brains, instinctively, that is something that we know and understand on an innate level to a degree that is even better than verbal language.
Well, yeah, everybody would agree that in the language, like, oh, look, mom looks pissed, stay away. That we all do that. It's survival. Yeah. But it's he looked up to the left and then he glanced over on his right shoulder 2 times. That means he did it. That is the witchcraft part of it. And
right, but you're exaggerating what is being done to an extreme point to prove a point, which is fine.
That's what we do as lawyers, by the way.
Yes. But I was going to say, Eric, I was going to say, though, in addition, when those like the professionals who do the body language evaluations, they have like 150, 500, 1,000 hours of tape of you going about your day, so they can make an educated guess. Yes, all the douchebags that show up like on Court TV or something, yeah, they're all hacks. But the people who really do it, and they also acknowledge, I'm just one piece of the puzzle, but it helps fit together what they're working on.
And there are certain things. There's things like baselining that help compensate. When you say, "Oh, looked up to the left," well, guess what? We all do look a particular direction when we do something. It's not always up to the left when we're recalling, but if you get there and you watch somebody, you video them, you ask these questions, you're like, describe your path home. You'll see that they turn consistently every freaking time. So it's a repeatable action. And that's a lot of what they're looking at. They're not just saying, oh, I'm going to conjure this up, but they are actually saying, what we're seeing here, okay, in this conversation, they're asking this kind of question. They seem to be doing this. And they're saying, okay, so they're not only looking up and to the left, but they're also licking their lip really quickly. They didn't lick their lips the entire time, but you asked them that question and all of a sudden their mouth is dry. Now, when you get nervous, your mouth is dry. So there's so many layers to this. And I'll throw it, like Chase Hughes. He's a PhD in neuroscience. And he's one of the behavior panel who's doing this witchcraft. So careful on it. I get
Can
it, and I can go both sides, but
I'm going to say that for me, as an attorney, using behavioral science or looking at what people are doing physically counts most when you're in front of a jury. And so I'm watching people in front of juries, these cases that I'm covering and things like that, and I'm looking at them. How is that going to be perceived to the jury? Because at the end of the day, that's the only thing that really matters. It doesn't matter if someone else out on YouTube or anything else can say, oh, he must be lying. What matters is how the jury is going to perceive your looks. I'm covering the Border Patrol murder trial. And the defendant just has a punchable face, and every look he gives, he has even more of a punchable face. And to me, that looks bad. Just his demeanor, and it's not good. And I would try to coach my clients. We're not going to look this way. We're not going to do this. We're not going to say that.
Do that too.
Because of the perception that it gives to the jury at the end of the day, and that's what I'm focused on.
Well, the good thing is it's inadmissible. None of them are none of this is going to be admitted in court. And just like the polygraph, thankfully, which is bullshit too.
Yep.
So if we want to talk about bullshit, polygraphs are bullshit. But a polygraph examiner is
trying to admit a polygraph on a civil case. It says there's a rule. I'm like, okay, good luck.
Right. Well, and by the way, that the polygraph, I quoted a guy who literally got the law changed about it, went in front of Congress, very irascible fellow. He calls the polygraph a rubber hose. I agree with him, but that doesn't necessarily mean that the polygraph examiner is doing a poor job. They can extract a lot of information, and the polygraph can be seen as a tool, or they're using it as a tool because they're like, oh God, especially if the person believes in it, the placebo effect can cause that to go. There's interrogation. I mean, there's so much. I know we've talked about this a couple of weeks back.
That was the critical thing, Eric. That a polygraph examiner also does an interrogation with it. That's what makes them very good at it. Not just sitting there analyzing the chicken bones, but when I've had to send clients out to get a polygraph, the guy they go to, well, he does the polygraph, but he also sits there and, he's a former cop. He interrogates you, and
it's
that's
tactical.
where,
Now, the irony is that a good polygraph examiner is just a good interrogator. Take the machine out of the room, and he probably would get the same result.
Well, that's what he does. Like after he does that, but then he also questions them, and he kind of tells me what happens. And so there's times where he's done the interrogation first, and he's like, I didn't even have to run the machine. So.
Well, I think there's some kind of placebo effect with the machine. I've seen interrogations like Chris Watts, who killed his family in Colorado. Like they use the polygraph to eke a confession out of him and to get him to tell them where the bodies were. He had not previously been able to come up with that, but he sat there and he believed in the test. He believed that the test could show that he was lying, and then he confessed. So it got closure for the remainder of the family. So it can be a meaningful tool, I think, sometimes.
And I'll even give in the Chris Watts case, much of the credit can be given to his father, because his father kind of came forward and he's like, son, you gotta, so there's a lot of factors. And again, all of these things are tools. And, especially in terms of investigation, I know all these guys personally, as you can tell, but they will even tell you, well, it could be this, it could be that. This is problematic with what is going on with them. Especially you have different medications. One of the things they going to the behavior panel have pointed out about Kohberger, which is interesting, or at least Scott Rouse did, is that he does have signs that he could be on an antipsychotic medication. Not necessarily because he did this thing, but a SSRI or whatever, because there are certain things he does that people on that medication tend to do. That's, it's medical science. They say, here's a typical side effect or reaction to this thing. So I don't know. And
I always pride myself on being a study of human behavior. I like the idea of knowing why people do things. So I do think that there is some truth behind the behavioral scientists. I just, in my what I'm doing on YouTube, I guess, is more focused on what's actually going to be admitted into court, and what's not going to be admitted into court doesn't really matter at the end of the day. So that's why I always focus on that. And my clients facial features sitting there at the table is going to be part of the trial. So let's take a look at that.
Or the jury. I mean, I literally, you're
jury
picking
too,
a
yeah.
jury. If somebody gives you a bad vibe, whatever it is,
Yes.
you could be completely wrong. They could have just been, maybe they're late with a parking meter. That's a famous story by Joe Navarro. It doesn't really matter. Am I wrong? Am I wrong? If any of you have a bad vibe about a juror, you're not going to go, oh, the guy creeps me out or he bothers me. Well, that's just witchcraft. So I'm not going to call the juror.
I have the exact
All right, I
opposite.
will.
I actually had a child abuse case that involved spanking by a stepmom, and I had a prospective juror that was on the panel, and an elderly Black woman. And every time I spoke, she was, nodding along and smiling. And every time the prosecutor spoke, she was just like frowning and really angry. I was like, I need that woman. I need her on the final jury. She can't be excluded. And sure enough, she was the one that came up to me at the end of the trial and said, I convinced everyone else because this was BS. And
yeah, that's one of the things about jury selection that I think is underappreciated is when you do it well, how much of it is intuitive. It is based on that kind of gut reaction and these. So the behavioral panelists are very good at articulating what is going on that we are already perceiving, but we just are not mindful of it, and we aren't able to really put into words what is making us have these reactions and these connections to things. My example is the very first jury trial I ever did. One of my prospective jurors was a retired deputy sheriff. I liked him. I left him on. And everybody, in my office thought I was absolutely insane. But yeah, he ended up being my foreman and he ended up delivering the acquittal. So the intuition in a lot of those types of decisions, it really can't be overstated.
Yeah, and a flip side of that story, going to Scott Rouse. Scott Rouse used to be a producer in Nashville for musicians. So some of his experience is kind of an odd background, but he would go into a meeting and they have a tendency in Nashville, for example. Let's say you're a young and upcoming artist. Let's say Chandler is just this new hot country singer who's very similar to a really popular act. So the label of the popular act will go, hey, Chandler, oh, you're amazing, and sign Chandler to a label and stick it on the shelf and never release it. Meanwhile, Chandler can't do anything. She's completely trapped and in a hole. Well, that's where Scott would be useful because he's producing these people. He'd go into a room. But as Scott put it, if you go into a room and there's a deal and they're like, oh, wow, oh, and they're really interested and they're excited, you're in deep trouble. Mm-hmm. The one that you want is the one who's sitting back going, and kind of a little skeptical, a little withdrawn. And again, this is the body language thing, but as he's put it really well, a lot of times the counterintuitive thing is that person's going, do we have the budget for them? They might be able to go here. I don't know. And they're actually considering. So they're in a mode of a decision. So that's what some of the stuff is too. So there's so much, more breadth to it than just looking at an instinct.
But bringing it back to Kohberger,
yeah.
I feel like it's doing this sort of it's like when police hone in on one particular suspect without really looking around. If you are looking for something, you are going to find it. So if you're looking for suspicious behavior, if you're looking for something a serial killer would do, you're going to find it in the guy that you're convinced is the serial killer, even if you don't have evidence, even if you
confirmation bias,
even if you aren't certain, even if there's nothing direct to tie him to that crime. So everybody who's looking for those things in Kohberger, they're going to find them.
Right. And I do understand that there was a controversy of body language and the judge ruling that no close-ups and this and that, which, okay, I get it. Do it with a witness, but not the defendant. Things I actually can support that decision, because that would be intimidating. If I'm trying to think of what if I was the defendant sitting there, and if if I'm constantly under, an ant under a magnifying glass, that really is not fair. And it could lead to bad readings or whatever, just by my discomfort of the focus or the knowledge that I'm being looked at all the time.
Mm-hmm. Yeah, and that's one of the common concerns that's voiced about having courtroom cameras in the first place is this idea that people are aware of them. They're not going to behave in the natural way that they ordinarily would because they're conscious of this lens over there that's staring at them.
Well, if you're a good defense attorney, your client should not be acting as they normally would either. They should be just sitting there, you know. If you've coached your client enough in his facial features and manners.
And that takes and it really hurt. It's really hard, especially if you have a client who's got, you know, resting bitch face, or they always sit there and try to react and they shake their head, or they do the and they huff, and you have to tell them, like, you are a statue right now.
Right.
Yeah,
even,
and we have
even with the red, right?
With the Border Patrol murder case, you know, I said he's got a really bad smirk on his face. He looks kind of like a Jersey Shore guy, you know, from the TV show. And we're sitting there and we're looking at him, and he's not making any emotions whatsoever when they're talking about these deaths of a child and a mother. And, you know, but somebody commented, well, if he makes a face, then he's a cold-hearted killer. If he stands there sober, he's a cold-hearted killer. If he smiles, he's a cold-hearted killer. You know, it doesn't matter. He's a cold-hearted killer.
Right.
Yeah, exactly.
So just be a statue.
That's been a problem in the Melly trial, I think, which I've been coming on with Jeff for. And you have this guy who, you know, he has some diagnoses. He's like on the spectrum. He has ADHD, and he's sitting there and he's kind of like laughing and smiling and smirking, you know, when he's sitting with his attorneys, and it's kind of a problem because it looks like he's not really taking it seriously.
No, I totally agree. And now the cameras in the courtroom. My issue is that the close up. I think it's very different if they have cameras. They're all mid distance or whatever, and they're just there, because then it's like you are in a courtroom. You just kind of look around. What have you? It's the close-up stuff that is very problematic. And if the cameras are just there, it's sort of like when you go to Walmart, do you notice the cameras? Because you can't pay for anything without being on camera. You can't walk down any there are cameras, and I just know them, you know, just midway down the aisle, little tiny camera. Everywhere you go, there are cameras. You know there are cameras. Guess what? You forget about them. Reality TV, that's how it works, is over time. And they have people actually holding cameras, following them around, and they literally wash out those people. So maybe everybody's going to act a little that way, but we can only hold that in our heads so long before we start to just say whatever and act normally.
Well, right. I mean, that's it. You have to have the cameras in the courtroom to the point where, as you said, people just don't notice them anymore. It just becomes part of the furniture, part of the background, and you don't pay attention to them anymore. You just have to. And that's what I want. I mean, I would love to have them installed to where every trial it's just there. It's just a thing. It's just some boring, like almost like security footage feeds, I think would be the appropriate way to do it. And then people can look at the different ones, but it's not edited together to create a narrative.
It's editorialized is the problem. You know, you get a witness that says something, you know, alarming, and then suddenly there's a quick pan and zoom over to the defendant's face. I mean, this is telling a story that is not actually happening except in the camera person's perspective.
Oh yeah, because it's like, oh, they said something. Oh, quick! What? Yeah. How did she react? And Zachariah Anderson case, is that not kind of what went down with him and his daughter about this bit?
Oh yeah, and they completely ignored the mother in the audience that was literally signing to the child.
Yeah, right. To be calm.
She was a sign language interpreter, and she was in, you know, like they were both doing it, but the cameras only caught Zachariah Anderson. She ended up being called up to testify about it because it became such a problem.
And I hate to bring this back to behavioral analyst people, but there's one guy that I'm going to light up this week, probably this week or next week.
Cool.
He's one of the smaller body language expert quotation mark people that analyzed the sentencing of Zachariah Anderson.
Well, who is it? I want to know, because I know all of them in some ways, or know of them. Which one?
Dr. G.
Dr. G. Oh, that guy's okay. Never mind. Go to town.
No, I'm going to light him up because he walks into the Brian Kohberger. Zachariah Anderson walks in the courtroom, and you know, he does kind of this thing. He's like, oh, there he is. You can see the smug look on his face. That indicates he thinks he's above this. And he doesn't take this seriously. And I'm thinking, or he's looking at his freaking sister and brother he hasn't looked at for 3 years. That might be a smile he was giving them. Just when you take something so totally out of context, you've seen this one time, you're watching the feed that the Law and Crime or whoever gives you. So you're already seeing a perspective that the normal person wouldn't be, like the close-ups and things like that. And
that's
it's a one-off thing. It's a one-off thing, and you just
wait. Are you talking about Dr. Grande, who is I'm not a fan.
Dr. G Explains. Dr. G Explains is his channel.
Oh, okay. Well, there's another one out there. This
Todd
guy
Grande.
I know Todd Grande.
Yeah. I'm not a fan of all Todd Grande stuff.
Yeah, this is a guy that Dr. G Explains is his channel. He's got like 47,000 subscribers.
Okay.
I wonder what he had to say about the Murdoch case, because the cameras were literally on him. They had just a special camera just for him to watch his reactions the entire trial, which was very prejudicial in my opinion, but you couldn't really do anything about it. And also it's not really prejudicial to the court. It's prejudicial, just in public opinion. Then again, everybody kind of decided he was guilty ahead of time, all the 20 specials, etc.
Yeah.
I gotta look this guy up, so thank you.
The wine mob crew, etc. The majority of public opinion. You saw the Law and Crime chat. I'm saying Law and Crime chat. The 13th juror. We're all voting guilty. Yeah. So majority of people were convinced.
Yeah,
right.
I don't think the judge did him any favors, though, especially letting in all the propensity evidence of him lying and all that other stuff. That is, he was convicted of being a bad guy. I don't think he was less convicted of the murder than being a bad guy.
Well, we saw a lot of room for reasonable doubt. I mean, that was how I came on to LawTube. I came on with Jeff and we were watching the trial, and, we were, I was convinced at first, and then I kind of started to see, well, I don't know, there's some wiggle room here. There are some things that are not totally clear. But then
Nate,
again, due process.
Nate, did you switch your mic? Because you were crisp and clear before, and now you sound like really, really distant.
Oh, hold on one second.
Because I was thinking that, we have our affirmative action attorney online, so you could tell us about this.
See, his mic has already failed. That's how quickly this happens. This is how quickly this happens.
They can't run microphones.
Seriously.
Audio.
Black people's microphones in America are never going to be able to hook up to audio if we don't have affirmative action.
Yeah.
Erica Marsh.
You were saying, Nate?
I don't even know what I was saying. Is my mic better now?
It is a little better.
It's like, this is it, unfortunately.
All right.
It's just echoey. Like you're
in the bathroom.
Large, empty room.
Yeah, I am. That's exactly where I'm at, in a large, empty room.
That's why it sounds like you're in a large, empty room.
All right. Well, tell us about the decision, Nate.
Oh, the affirmative action, since I'm in my large echoey room, if you guys can stand it. But
it's like the voice of God. We love it.
So essentially,
echo chamber.
The Supreme. This is an echo chamber. Essentially, Supreme Court overturned affirmative action. Now, this affirmative action, a lot of people don't realize, but it started from, we can go back to Plessy v. Ferguson, separate but equal doctrine, and then the overturning of that for Brown versus Board of Education. Essentially, in Brown versus Board of Education, it was found that the separate but equal doctrine wasn't working because even though they were separate, things weren't equal. There are a whole bunch of cases about, like there's a law school case where the University of Texas, for instance, said that we're not going to allow Black students to the University of Texas. So the student was like, well, if you're not allowing Black students in, then we're separate but equal. So they made this fake law school up, called it the Law School for Negroes. Hopefully that doesn't get monetized. Literally, the Texas Law School for Negroes, and didn't have any faculty, didn't have anything. Yeah, so the NAACP was suing all of these states based on this separate but equal doctrine. Obviously, it didn't work out for the states. So separate but equal was struck down. But then you had the next issue was, okay, so now you've ended racial discrimination. But now for the past 150 years, you were not allowing Black people to go to law schools and med schools and all this other stuff. You don't have things like legacy where you have the legacy admissions where if your father's a doctor at the school, then you can go to the school and become a doctor and things of that nature. So they had this issue where it's like we made everything equal, but now we allowed these people can't get into these schools because obviously they weren't equal. So then you had affirmative action, and affirmative action kind of started in small little pieces. The first piece was, I don't know if you guys, in 1977, where you had like the Bakke decision. So from 1954, from Brown to about 1977, the courts, with the states, what they were doing is to fix the past racial discrimination with just having like straight quotas. So for instance, in the Bakke case, the state medical school had 100 seats for for med students. And they said, okay, we're going to hold 16 for Black students. So those 16 we had to fill those 16 seats for Black students, and all the other ones we'll let the white students compete against. So Bakke was like, well, hold on, that's reverse racial discrimination, right? Now I can't get in because all those seats are filled. And even though I have, these strong, outstanding numbers, great GPA, great MCAT score, you're allowing inferior students to get in, but just based on race. It was essentially reverse racism. So the Supreme Court rejected that and said, okay, you can't just have straight up quotas because that's racist against white people, and we're trying to end racism. So we have to think about a new way. So that new way was, we're going to use race as a factor instead of an element where, if you're not white, you're out. We're going to use it as a factor, and that factor would then be, if we want to, and if the reason for that would be, we want to diversify the law school community and the med school community. So we're going to use race as a factor. So that brings us to the Grutter gloss, and that's in, I think, 2002. So the Grutter gloss is a young white woman. Her name was, I think, Sarah Grutter, but her last name is Grutter anyway. Interestingly enough, one of my bosses when I was teaching at the law school was the administrator in this particular case. So what happened in Grutter? Now this is what the Supreme Court. This case now actually overturned Grutter. Now the Grutter gloss was Sandra Day O'Connor. There was an argument on the Supreme Court between Sandra Day O'Connor and Justice Stevens at the time. Justice Stevens said that they had bastardized the 14th Amendment because the 14th Amendment, which is the Reconstruction Amendment, was put in place for one purpose: to help Black people overcome racial discrimination. But Stevens said that the conservatives on the court had bastardized it and essentially created what's known as the Stevens anomaly, saying that now the 14th Amendment restricted Black access to schools and things of that nature when it was actually created to help them get into that place. So it became the Stevens anomaly. And they said, well, listen, now because Black people can't get into these schools, then unfortunately, you've made the 14th Amendment essentially a tool for racism. So in Grutter, Sandra Day O'Connor, who wrote the opinion, wrote it for that reason, to show that, yes, we could have this caveat of race be used in admissions without it being discriminatory. And that's where you had now race as a factor. So that's what we've been living at. So for instance, when I was an administrator at the law school, so I taught at a law school for 2 years, and I was actually involved in admissions. And what we were able to do is say, okay, we couldn't say we had X amount of Black students, but what we can say is, well, is our law school diverse enough? So yeah, if we have somebody with a 4.0 GPA and someone at 2.5, but we have 99 white students, we can say, well, we want to let this Black person or Hispanic person, for diversity, right? We want to make so it wasn't based on race particularly, but it was one of the many factors that we would use to bring it in. But you would also have to check a box. Now, checking that box got you a lot of interesting things. It got you free money. It got you a lot of different things. And now, coming up to about 50 years after all of this happened, now we get to this ruling today. So there's two things that this ruling tried to address. Number one, how long is this going to go on? Right? How long do we have to now continue to use race in the admissions process? Because even in the Grutter case, when Sandra Day O'Connor wrote it, allowing race to be used as a factor, she even said that this should be done in about 25 years. Right? We can't do this forever. This is a means to fix the ills of the past, but this can't just go on forever. This type of discrimination. So two states, and a lot of liberals don't realize this, two states initially just did away with it: California and Texas. And the one thing I love the Texas model, because the Texas model I think is the best model, is because it addressed two issues. The first issue was the liberals were saying, well, the Black schools in the poor neighborhoods are inferior to the white schools, right? Because there's more money in white schools and all this other stuff. So the way Texas fixed that is said, okay, we don't care what public school you went to, but if you're in the top 10 or 15% of any public school, you get admission to the Texas schools. So it doesn't matter if you were in a poor failing school, or it didn't matter if you're in a great school. You were given a ticket if you were in the top 15 or 10% of your, I forget the number, but if you're in the top echelons of your school.
So it's meritocracy.
So it was merit, yes. So now it took away the race, but then you still had that same, you still had the elements of race in it, but it wasn't dependent on race. It was just say, hey, if you went to a school and you were in the top 10% and the state funded it, then guess what? You're going to get into it. So after that happened, and California just did away with the practice altogether. What you did see was a lowering of Black and Hispanic students in the more predominant schools, but then you saw an increase in them getting into schools that they were better prepared for. Now, this happened with me when I was in law school, and when I was both in law school and when I was actually helping in admissions for law school. What we would do we were essentially trying to fill a quota that we couldn't fill. And one of the things that occurred when we were trying to do that was so when I started law school, I had a friend, his name was Antoine, and he was Black. He had gotten money like me, he was Black but he had a horrible GPA. Now, I had kicked my ass to get a great GPA because I forgot race mattered. So I was like, I'm gonna kick my ass to get a great GPA and get a great LSAT score. And I got in and got all this money, but then it was this Loof, and he got the same amount of money as me. He had a horrible GPA. And when we went through the first year, I remember the professor said, well, listen, if you don't take this seriously, you're going to fail. You're not going to make it out the first year. You're going to fail. This guy, he didn't study. He didn't study. He did nothing. But he just thought because he was Black, he was just going to get this opportunity. And he failed. And then they allowed him to try back. And then he failed again. And what we kept seeing, even when I was there, is that they were just pushing people like, hey, come to law school if you're Black or Hispanic. And those people would fail out because they weren't ready for law school. They were just giving them tickets and just hoping they did well. And we've had this trend where most of our Black people who were admitting were failing, not because they were Black, but just because they weren't taking it seriously and were giving a free ticket. And the people who were taking it seriously, the people who had to fight for those seats, like myself, we're going through. And another thing that we started seeing is the Black guilt piece of it, where when I was my last year, I was really good. I was one of the top law students in my school, and we were in torts. And I graduated from City College, and there was somebody in my law school who was from Princeton, and she was failing our torts class. And the torts professor was like, yo, Nate is really good at this stuff. Nate knows this, he's fucking like a savant. Why don't you hook up with Nate? Because I was holding class while in law school. So how nerdy I was. I was actually holding review courses from all the classes. So people were coming. That's why they gave me a professorship right after I graduated. But anyway, I was holding these review courses and people would come. So she had told the professor, she was like, hey, listen, nobody from City College can teach me anything, right? But after when we graduated, she then came to me after graduation and said, hey, listen, I thought that you were just someone who got a free ride. I didn't think that you were somebody who actually earned your spot. And you did earn your spot. And I honestly didn't believe that because I helped her pass torts. So that's essentially what was going on now. So the Supreme Court now essentially said, hey, listen, we're going to stop all this bull crap. We've been doing this for about 70 years. We've been doing this for about 30 or 40 years, and now we need to cut the cord now. So there are a lot of people out there saying that they've just stopped using race, and that is not true. What the Supreme Court has said is that you can't now use race as a factor to determine who's going to get in, who's going to go out. People can talk about race in their essays. They can let you know what their race is, but you can't consciously say we're going to let more Black people in or white people in. Now, what most schools are now starting to do now, because I know these were some conversations people were having then, is that when this ruling, because they knew this ruling was going to come down, because we used to go to conferences with other administrators, they knew this ruling was going to come down. So what they're going to do is things like zip code. If you have a zip code that's 80% Black, then we're going to look for people in those zip codes to try to let them in. We're going to there are other race neutral means, but the easiest way was to just allow them to discriminate, essentially against everyone else to try to get those numbers. So I think this ruling, for me personally, I know people are going to be upset when I say this. I think this ruling is a good thing because it forces these college administrators to get off their behind and actually start doing their job, reading these things about the students, finding out who they're letting in, and not just allowing people to check a box, give them money just to say that you are trying to be diverse. Because those students, I'll tell you, the travesty in law school is those students who failed out, which I'm telling you, like we had like 6 black men, and like 4 of them failed out. And the reason why, and when you fail out of law school twice, that means you can't go back. No other law school is going to take you. It's going to be really hard for you to get someplace else. And even if you do get into another law school, it's probably going to be a shit law school, and you're going to have to pay top dollar to go there and have maybe $300,000 or $400,000 in debt coming out. That's what was going on. And a lot of those people who failed out couldn't get back in. So now I think the Supreme Court is saying, no, you have to do more. You can't just check a box, and you can't just say, I need a black face. The person has to be able to do the work, and you can't just take their money and call it a day. So that's my little speech about affirmative action. I hope I think I went through everything. So
it's fantastic. Haven't they done studies of, like, I think at Brown University and others, that students were put in a more difficult position, whereas if they had to go to community college or state level school or whatever, they probably would have been incredibly successful. But because, they're jamming them into Harvard, or they're jamming them into like really, really hardcore programs, it's doing them a disservice.
Yes, I do think that it was doing a lot of students a disservice, because listen, if you send someone, we all know who've gone to law school here, the rigors of law school. And if we don't understand, if someone who doesn't have that ability because there's study habits involved, there's the rigors of reading and those type of things. And a lot of those students who got those free rides didn't have those study habits from undergraduate school. So that's what made them fail when they were in law school, because they just weren't used to doing it. So, the big issue was getting people who are motivated and had the tools to actually be successful in law school. And we just didn't have that from a lot of the people who we had coming on.
Couldn't we solve this issue by going by class versus race anyway? I mean, but that's part of my problem with a lot of these is there are poor people all over, or people who need help all over. And if there happen to be more people who are racially different who need help, fine, then that'll kind of come up naturally if you go by class, or if you go by the amount of income, things like that, to try to help all people.
You're talking about socioeconomic purely?
Yes.
Take that. Okay.
Yeah.
That's what Texas did, though. That's why I said I love the Texas model, because that's what Texas essentially did. Texas said, hey, what we're going to do is that we're going to take race totally out of it. But we're going to say, if you went to high school in Texas and Texas paid for it, and if you're in the top 10 or 15% of your class, then it doesn't matter. It doesn't. If you're in a poor neighborhood, if you're in a rich neighborhood, you're going to make it in. So I think it addresses that issue and removes race from it. And then you're eventually going to go and get, when you get those black high schools, 10% of those top kids are going to be black, and they're going to be the ones going into, you know what I mean?
Yeah, I've got shifting boxes all over the place.
Ron, come back.
Ron's here. Ron's gone. Ron's here. Ron's gone. Goodbye to Andrea. We knew Andrea was going to dip out, but she didn't want to interrupt because Nate was making a good speech. So thank you, Andrea. Guys, jump in.
So no, I was my whole thing with affirmative action. Even if I like Nate's analysis, I agree with him, and that's why it's hard for me to believe that he's not conservative. But I wondering if you base it on socioeconomic status, aren't we just perpetuating one of the same issues, that is people that aren't necessarily qualified or able to perform successfully in these schools are still going to get in?
No. Because, like Nate just said, if they're testing high enough, wherever they are, cool. You can also mitigate that. I feel like if okay, there's going to be a problem, why not just say, here's the extra pre-law year that has to occur, or whatever. So you're saying you're allowed to go to these courses to brush up, because they have them for math all the time, right? I mean, there's a ton of us who suck at math, and there's all kinds of remedial math training and things of that sort. So why not have that? Why not just say, okay, these are potentially really good candidates. have some makeup courses, again, socioeconomic versus racial, and you can possibly bridge that. Or you just say, sorry, you can't get into the school. You can only go to these state schools that are at this particular level. I think that you can definitely mitigate the issue, though. And if they're going into a remedial type of program, well, it's no harm, no foul. If they fail out of that program, well, they weren't into the law school. So they're not necessarily banished from another law school. I don't know. Nate, I see you're off mute. So go. Tell me where I'm wrong.
I agree with you 110%. I think that's the kicker here is that the schools now, it was easy to use race, right? If you're black, don't worry, we'll give you some type of advantage. But now it's kind of like we have to now, not only we got to look to see who the person is. And now since we don't know how the race is do we believe this person can actually do the work here? And if they happen to be black, that's a wonderful thing. And it also, I think, forces people to also understand the problem with just education growing up from that point of view in terms like here in New York. If you go to a school in the hood, those students are unfortunately not being educated as their white counterparts. But the interesting part here that I think kind of turned the tide here is that there has been for the past 15 years. You guys may have heard this. All the schools in the hood are bad. We can't treat these children are failing children, that type of thing. So in New York, there was this. It's called Success Academy, and there's a charter school. And what they did was they said, okay, we're going to go to the worst neighborhoods in New York City, the blackest of the black neighborhoods, and we're going to teach these kids and get them up to grade level. Because it was accepted that, hey, if you're in a black community, you're going to go to a failing school. So Success Academy went into the black community and opened up these charter schools. And if you can look at them on now, they're actually outperforming their white counterparts in New York. And they are some of the top schools in the state. Now, these are schools in Harlem, in some of the toughest communities with all black students and all Latino students, with like a 90% rate of going to college. Now, most people probably have never heard about this, are probably shocked. Now, why was this?
Unions hate them.
Unions hate them, yeah, and the school board hates them too. Matter of fact, the school board tried to create a charter school, and the charter school failed, even for the school, for the teachers union. But what it showed was that it wasn't the fact that it was the fact that the African American and minority students were being failed by the politicians in those areas, and not by these school administrators. It was the politicians who were putting them in failing schools. And then when and now there's the sad part about it, they've been trying to close the success academies now. They are literally trying to close schools in the poorest neighborhoods in New York that have 99% pass rates in math. They have 99% pass rates. They want those schools closed. And they want to put those students in failing schools. So that's the issue. I think that the Supreme Court says, no, it's not. This is now a political issue.
Welcome to equity, Nate. Welcome to equity.
The
easiest way to make people even? Smash them all down.
Yeah, this is not an issue about discrimination anymore. This is now an issue about policy and politics. And that's what the Supreme Court said. Now let's put this in its rightful place. You fix the problem with the education system, and we're going to continue to do this in a race-neutral way, because it's not about race anymore. We see that now. It's about your policies in Baltimore and New York, putting kids in failing schools when you see that there's a way to get them out of it. Sorry about my rant.
No. Welcome, Ron Coleman. How you doing?
Thank you.
Well, you're on with the wrong mic, Ron. You might want to check that. You're coming through your laptop mic.
Nice to meet you, Ron.
Hi, Chandler.
Hi, and Shabbat Shalom.
Oh, thank you. Yeah, we got some time.
Unless you're in the future like me and it's 2 a.m. on Saturday.
Well, good point. Anybody have commentary for Nate? It's kind of a big decision.
Nate is trying to make a decision?
What's the Boozy case? It's like it's crazy every day. Boozy. Like, what's
Goodman.
On a roll?
Hold up. Boozy is not getting attorney fees from Goodman. So there is a silver lining in there. Did you see that?
Oh yeah. But Boozy's Boozy. He's crazy, and we all knew Goodman's only hope was the default judgment. So when that went away, his case went away.
Sure. Well, that's what I'm saying. He's lucky that the attorney fees didn't get granted, because I feel like some moves were made by him that may have harmed his status. Oh, here we got entry required. Nate, let's go back to the 70s when I remember this stuff. Tell us about Regents of the University versus California versus Bakke or Bake. Oh, Bakke.
Yeah,
you did talk about
I
that.
was talking about that.
Yeah, that's what you
Yeah.
opened with. Sorry.
Mhm.
Matthew Self.
Now we
See,
know
I'm
how to spell
thorough,
it.
Matthew.
Thank you very much. Yeah, I was on with Nick the other night. That always fun, always cool seeing that. And
He always goes off YouTube and onto Rumble the second this topic gets good.
it's
It's almost as
think
if he
it's cool.
plans that. doesn't
Right?
it?
Yeah, who's the biggest channel here? The one we're talking about, right? So I wonder why. But yeah, Eric Hunley Defense Fund. Yeah, Anyway, fun times. Those who haven't heard, I have a little bit of an issue with a New Mexico prosecutor, and Nate has some involvement in that.
Oh yeah, Nate, are you allowed to talk about it?
Well, I'm his client, so yeah, technically.
Yeah, if Eric allows me to talk about it, I can talk about it.
Yeah, talk
No,
about it.
but essentially, the New Mexico special prosecutor wants Eric's source. Eric is an independent journalist, and obviously, he's been working on he's like the foremost expert in the Rust tragedy.
I wouldn't go that far, but
I don't want to call you. I don't. Yeah, unfortunately. So anyway, you've developed some sources, and you get information, and you do the show. America's Untold Stories. Don't forget to check it out and subscribe, people. America's Untold Stories.
oh yes, please, and subscribe here.
Yes.
Look at this panel. I mean, I'm sitting here. It's like I'm pulling in all these giant lawyers, and I'm looking. It's like, oh, maybe I'll get 20 more subs this week. Oh, come on now. There's 1,600 people here. 1,679 people watching. Come, hit it. And don't do it for me. Do it for all these other people.
So there was there's a rumor going around about some planking that may have occurred, because obviously the biggest question in the Rust tragedy was essentially where did the live rounds come from?
Mm-hmm.
Were they brought on by the armorer? Were they brought on by somebody else? Where did the live rounds come from? So if the armorer was shooting live rounds before set, then obviously it's going to let you know, okay, it came from her, giving her more criminal liability on the set. Now we know why how there were live rounds on the set that there were no live rounds. So the DA, because now Eric heard this rumor and he reported, was it last week on this show, right? Last week?
Yeah, this show and America's Untold. Yeah, we talked about, because, well, I've asked about where are the live rounds over and over and over, because I feel like it's not reported enough in the news. And so as soon as I heard the information or the rumor from one of my sources, I was like, oh, okay, it turns out I may be reporting this wrong. I just heard from a source that there was plinking going on. And that got back to the Santa Fe special, or New Mexico special prosecutor. I guess it would be Santa Fe special prosecutor, because it's the city that's going after.
Yeah.
Right.
So the special prosecutor essentially was like, okay, we want to know your source. Now, another one of Eric's sources, which is funny, kind of set him up and was working for the DA, unfortunately. So the DA reaches out and wants us to and wants to talk to us. So the DA is now threatening subpoenas and all this other stuff to find Eric's sources. But it's a bluff, because obviously to have a subpoena, not a subpoena,
Search warrant.
Search warrant. So she said, search warrant. We're gonna file a search warrant against you guys. But that's bullshit, because to have a search warrant, you need some probable cause. Every attorney knows here. Probable cause that a crime is committed and that Eric committed some type of crime, and there's nothing here, obviously, that generally we're talking about maybe a subpoena, which I've done before at the DA's office, where the DA sends a subpoena to some companies, mobile phone company, and we can see who you were talking to, but we can't see any of the context of the conversations. So maybe that's the extent. I'm thinking she may have meant subpoena, but she said search warrant. So right now, there's really essentially nothing to worry about. So
how many times did she say search warrant though?
She said it a whole bunch of times.
Exactly. So I was gonna say I'm not getting one slip of a tongue, and the way she hung up was, I'm hanging up now and filing.
Yeah, because we called her bluff. So, now we're waiting to see what she comes back with. But I'm assuming, if it's something, it's going to have to, she's going to have to overcome probable cause for a search warrant. So I'm thinking she's subpoenaed, but we'll find out. Ruby is really good. Ruby is another high-powered attorney. So.
Yeah, do you want to come here, Rubia? I don't know if you follow me on Twitter or I can get a hold of you there, but happy to talk to you. And thank you very much. That's very generous of you.
Well, just remember, Eric, Judith Miller spent 85 days in jail not revealing her source. So you know what the high score is.
No, stop that BS. Okay, you're trying to do a Viva Fry on me.
You are.
It's the worst thing. Here's a piece of advice: if you ever get into a weird spot with a homicide investigation prosecutor bugging you, it might not be a good choice to go on with Viva Fry with all of his anxiety and neuroses, asking you every question in the world, very similar to what Sean just did to me there, where he says, well, I'm talking to people in Canada and they're saying freedom is my mistress. And I'm like, no, I don't need a mistress. I'm married. Okay. I need to stay at home with my wife. I don't need to go visit a mistress in a cell somewhere. Thank you very much. But Nate even called me the next morning because he had heard, he goes, are you okay? Are you okay? Because am I exaggerating, Nate? Nate?
No. I was concerned about you, but it because again, you got this special prosecutor. I'm going to give you, a search warrant and blah 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 blah. But at the end, it's like this is all BS. She bluffed. We called, and now we got to see where she comes out. So.
Well, that's always one of the hard things that we do as lawyers that we sort of take for granted. But when we know these things and we're telling the clients, don't worry about it, just relax, just put it out of your mind. You're like, how do I put this out of my mind? This is the only thing on my mind. We get paid. You pay us to worry for you, and they're like, they're still not buying it.
Yeah. Well, and also, I think the funny thing about that would be, given how they've screwed up this case and some of the things that have happened so far, overall, breaking on like front page of like all major news outlets, they're going after a guy on YouTube who lives in Virginia. It's like that's just going to make it look that would just make them look even more incompetent and like a bunch of boobs. So I don't think anything's going to happen at all. Just alone from that issue. And just unless your source happens to be a guy named 'cause I know you don't want to disclose it. Is it Alec B? Is that one of your sources?
Everybody's my source, Sean.
Everybody.
It's
perfect. The weird thing about this whole thing is that generally, like, we all hear about reporters going to jail for not revealing sources, but those are in very unique circumstances where, number one, there's no other way of getting the information but through the reporter. But here you don't have anything even close to that, and plus the information's got to be confirmed too that this information is real. So there's a reporter privilege. New Mexico covers it, and most states find it. So this prosecutor, she wanted to go the easy route. Tell me the information or else. So we chose or else. So we'll see what happens.
Well, I know for a while, Eric, that the way that you had discussed the issue was that you said there was a rumor that you weren't sure that you didn't have an eyewitness, but that it was just somebody who had heard things and therefore couldn't be substantiated. So to your credit, you never really put out false information. But I know that Alec Baldwin especially would love to find the source of those live rounds because he discussed it in his interview on ABC. So
I think it's critically important, and part of the reason I'm so upset about this is, okay, one, I didn't sleep well on Monday. I'm not going to pretend and say that this doesn't bother me. It does bother me. I don't know what could go down. I don't trust anybody in that regard. I was sitting there thinking, okay, I have do not disturb on my phone. Am I going to wake up with the cops because the Nest doesn't go off beating on my door because Hampton's going to, I don't know these things. I just have a stream with Viva Fry the night before. And yes, my worst imagination is going off, but I'm human. I'm sorry. It scares the bejesus out of me. The idea. Yes, I know I'm right. I know that I'm right. I know I'm in the right. but that doesn't really matter. It's like I could sit there chilling and lose all of my computer equipment or whatever else while I'm waiting to be proven right. And that still sucks. I've got to do this. This is my job. It's very important to me. So, you know, people are like, oh, think of the views, think of the clicks, think of the, no.
That would be awful in the meantime.
Yeah, there's a million ways to get those views and clicks, and I'll try all of them.
Well, you have a good attorney, so.
Oh, hey, absolutely.
So let him do the worrying for you.
And people will super chat you for commissary.
Yeah,
worst case
That's
scenario.
true. That's true. Get the good peanut butter.
God.
Ramen.
Get the Keefy coffee.
Yeah,
my clients like it.
Yellow bags.
Thank God I quit smoking.
Yeah, that would be an expensive habit in prison, I'm sure.
Yeah, I think the only people who think it's enviable to be a martyr or a victim so you can collect on the money have clearly never gone down that road to collect on the money. When they think that the recompense is worth it and like, oh, you're the big winner in the end. If you haven't gone down the road, it really you're seeing the grass as being greener when it rarely is.
I agree, and I guess to that point is it's not only for my personal welfare, safety, comfort. Let's just be honest, comfort. It's a matter of this is still an incredibly important case, in my opinion. Somebody died. It is not a joke, and wasting your time chasing me around is wasting time that could be spent investigating. That could be spent talking to people who were actually on the set. You have all of these people. You have video camera, we cop footage, everything in the world. Go do your job. And I'm just not trying to be rude, but do your job. Go talk to them. They're there. You can do it. But that's my opinion.
Yeah, no, I agree. I have no idea why. I mean, it's not like they could use any of your information anyways. Discovery, though, could lead to further discovery. But again, at the end of the day, they have all the information already.
If I missed this part of the story, I apologize. Do you know what information you let out that led them to believe you're a person of significant interest to them?
I talked about the fact that I heard from a source that plinking, in fact, was going on. And that was hit on this show last week, actually, and also on America's Untold Stories, where we do Rust coverage a lot. And I mean a lot, like an exhausting amount of coverage that we've done. But that's it. It got to the prosecutor. Another source was acting as an intermediary between the prosecutor and me. Then the intermediary was taken out and was direct contact. And
well, the one thing we know is that prosecutors are notoriously very, very concerned about leaks from their office. We've never heard in the last many, many years any leaks from a prosecutorial office. So I can understand if they felt something came out of their office, they would have grave concerns because they would be like the first time. That'd be like the first time, probably in American history, that we saw such a thing.
Wow, StreamYard's just giving me fits. I tried. What the hell? Megan, I'm trying to add Megan. Okay. Oh, okay. I added.
Hey, it's persona non grata.
Hi. I'm still alive despite YouTube's best attempts.
Wow. Well, and I definitely wanted to have Megan here too, because Megan's a journalist. I don't know if you've been through the same situation I'm in right now with New Mexico, or if you're familiar with it, having a special prosecutor wanting to serve a search warrant on you to give up a source. Is that
Yeah,
familiar?
I heard about that. Thank God that has not happened to me yet. So we'll see.
Before we go on record, I want to go on record with my YouTube overlords that I disavow any knowledge or relationship with that person sitting in the lower left on the lower left hand side there. That I have no relationship with her in any way, shape, or form. Or
I don't know. You're right beside her.
And,
yeah, Joe, like Redford said in the comments,
I do not endorse any of her views.
This is like all content used is fair use and belongs to its original creators.
Person, I just see a blank space. I don't see a person there. Who are you talking about?
Wait for a
It doesn't
second.
look like anything to me.
Howdy, Kurt.
Hello, how's it going?
Doing well. How are you, man?
I've been doing good. I've been covering a lot of Supreme Court case recently because it's that time of the year, and I'm still trying to figure out how it's possible that Harvard violated the Equal Protection Clause of the Constitution. And I think I'm going to write a legal note about it because I'm having such a mind attack on the issue.
Wait, are you serious, brother?
Harvard can't violate the Equal Protection Clause of the Constitution. It's not possible.
Because it's not a state actor?
Correct.
Yeah.
That's not what was decided back in Becky times. Didn't University of California versus Back establish that schools have to have that?
The University of California is the state. The University of California can violate the Equal Protection Clause, not Harvard.
Yeah, the university. The reason why Harvard though is because they have the federal. So the way they get the way they get it is that through federal funding. There's two little quirks. So for you to get student loans through the federal government, that's how they get them. So if they don't follow the federal mandates, then they lose that source of income, which is like 50 or 60% of their income.
That doesn't make them a state actor.
That ties them to Title VI.
Yes.
By accepting federal funds, they violate Title VI. But that's not what the Supreme Court wrote. The Supreme Court wrote several times Harvard is bound by the Equal Protection Clause.
I think
they're not.
I think they treat them as a state actor through that mechanism. But
that doesn't make any sense.
I may be wrong though.
I'm going to write a legal note about it. It doesn't make any sense.
Did you talk about this on your video yesterday?
Like 2 hours. 2 hours.
Okay.
I talked about it yesterday because it doesn't.
I've been told about it. I need to watch it.
Yeah. So that was fun and exciting. The other there was one case I actually did see an article written about that might actually be the most significant case of the year, dealing with this guy who was seeking for compensation from his railroad company for some cancer treatment, and the Supreme Court just basically wide opened corporate liability. So now they can be sued for general purposes, and any state not only in which they are residing, but any state in which the state demands it as a condition of them getting a business license, which basically will be every state going forward. So now basically every corporation can be sued for general purposes everywhere. And that's a pretty huge, significant change on personal jurisdiction law.
No. I'm not sure. I'm not sure that's right. Every corporation doesn't necessarily have a business license in every jurisdiction.
I did somewhat overstate my case. That's fair.
You did somewhat overstate your case, counselor. But
fair enough. I've been successfully chided.
I actually lost a motion on venue to Twitter last year, despite the fact that it has an office in New York with hundreds of employees, and Twitter New York has its own Twitter account, and in other words, they're very much doing business, and they're absolutely amenable. They're absolutely should contemplate being hailed into court in the state of New York.
Purposefully availing themselves of the jurisdiction.
They were most surely purposely availing their bad selves, but it didn't take. But I would have won that motion.
Yeah, you would. You might win that now.
Yeah, that could be because the Ninth Circuit doesn't want to let go of any.
I bet Twitter New York has a business license.
Lost this in New York.
Yeah.
Right, I'm saying
I bet Twitter has a New York business license, so you might be able to sue them now. So you couldn't sue them a year ago, but you might be able to now. So hey, maybe give it another shot. That statute of limitations hasn't run.
Suing Twitter is a fool's game, says the guy who sued them about 5 times.
Yeah, but I'll be amazed if every state doesn't enact laws that are mirroring Pennsylvania's. That's why I kind of overstated my case the way I did, because I'll be amazed if every state doesn't adopt. Yeah, by doing business in our state, you have to get a business license, and you have to consent to general jurisdiction. And I'll be it seems like it's a massive wide open. I was thinking about, in particular, like all the credit card companies, like Visa, and everyone crying in their soup as they now are subject to suit everywhere, and the South Dakota registration not looking as good as it did yesterday. Well, that's a little geeky technical. So we can move on.
Well, that's interesting. Could I then serve Facebook with a subpoena in Michigan rather than having to open an ancillary case in California?
Maybe.
That would be a lot nicer. And Google too.
Yeah, maybe.
All right. I kind of like that idea.
Yeah.
As a defense counsel wanting to get access to, certain Facebook things and Google Analytics and things like that.
Yeah, but now you get your choice of jurisdiction. One would imagine, because I would imagine in the future every state's going to open it up, and now you get to choose whatever state is most beneficial to you that day. So you get to forum shop like crazy. You get to judge shop, forum shop, venue shop like crazy. It's great.
I'm curious. Can corporations claim that they're grandfathered in if they're already in that state? That's not deemed purposefully availing just because there's a change in the law?
No.
Not if they continue to do business going forward. I don't think so. No.
That is rough. That's a harsh. I kind of like it. You're hitting on these national corporations where it's like, look, we know you're purposely. The reason you're setting up registration here is because you're planning on doing business here. Why the heck should you not be ripe to be sued in this jurisdiction? If no one told you have to be a national corporation, that's part of the cost of doing business.
Yeah. Especially in this day and age with as much traffic as there is interstate, and it's just getting worse and worse all the time with as much commerce as there is. Every Civ Pro professor out there crying silently into international shoe and have to rewrite their syllabus. So good times.
I would have said that, like, this is a radical change in that the use of the internet has created such easy interstate commerce that it almost makes the interstate commerce laws that predate by.
Wow, Joe, your phone ringing? What happened?
I think his phone is ringing.
Sorry about that. The interstate commerce laws from even 25 years ago are really irrelevant. But then I realized that federal government has claimed interstate commerce on everything for the last 100 years. So it doesn't seem like it's really that much of a change if you think about it.
It's an easy win. Interstate commerce clause is an easy win for the feds.
Yeah.
Which I disagree with wholeheartedly, entirely, and forever.
It's really it's problematic constitutionally, but I can't imagine getting that horse back into the barn.
I have dreams. Overturning Wickard. It's on my to-do list.
Yeah,
I'll get it done.
Can we talk about?
We have a court to do it, right?
Yeah.
Well, matter of fact, tell people what Wickard is, because I know people are like, what the hell are you talking about Wickard?
Oh yeah,
Wickard is
the wheat case. Yeah,
thank you, FDR.
Case.
Yeah, very famous case. A guy is growing wheat on his own yard for his own purposes. He consumes all the wheat he generates for his animals or himself, so he doesn't sell any of the wheat at all. It's all grown on his own farm. And the federal government says, well, this impacts interstate commerce because by you growing your own wheat, you're not buying it on the market. So your non-commerce, which happens wholly in-state because it happens on your farm. So your wholly in-state non-commerce is interstate commerce, which doesn't make any sense, by the way, but that's what they said. The non-interstate non-commerce is interstate commerce. And so this case, Wicker v. Filburn, I want to overturn because it doesn't make any sense.
But they said it tended to have an effect on it. It could possibly.
If everyone grew their own wheat, well, golly geez, there wouldn't be as much wheat on the open market.
But they affirmed that case twice, because don't forget the marijuana cases from California.
Well, Reich was wrongly decided too,
right? They were saying
Scalia didn't even have any big ones. Scalia came up with the wrong opinion in Reich.
To be fair, we're sort of, as attorneys, we're being a little bit sloppy here in glomming together three different areas, which are highly related, but not precisely the same. Meaning the availability to interstate commerce claims by the United States government is not exactly the same thing as long-arm jurisdiction. And long-arm jurisdiction is not exactly the same as venue. Those are actually three distinct things that we're sort of glomming together in one conversation. But we should be clear to an audience, seeing as how we're a panel of primarily attorneys. They're really different. They're not
bring
exactly
the language down. Yeah, nerds, bring the language down for people like me, okay?
Right.
Well, from my perspective, it's all the long arm of the federal government. No matter how you shake it out, it's the long arm of the federal government. How far are they reaching? And that's the fundamental issue. We are attacking it from various points.
But to break it down in layman's terms, when you're talking about interstate commerce, in order for the government to be able to, the federal government to regulate anything, then they have no right under the Constitution to regulate really anything at all unless it's deemed interstate commerce. Wicker v. Filmer came forward and basically said that pretty much anything can be deemed interstate commerce. So in that sense, that created for the government an availability to pass statutes, which would anything that's affecting interstate commerce. And the reason that Wicker v. Fillmore was passed was because a lot of the laws that FDR had passed under the New Deal were basically shot down by the Supreme Court as being beyond the scope of powers of the federal government because it wasn't because of lack of jurisdiction for the federal government to weigh on things that were not interstate commerce. After FDR threatened to pack the court unless this New Deal would be approved, all of a sudden they changed their tune and suddenly they found ways to start interpreting pretty much anything as being interstate commerce so as to retain their power and not have to worry about the court being packed. So that's where interstate commerce plays in. It's really primarily with respect to federal powers. When you're talking about long-arm jurisdiction, that is talking about it could, in theory, work with the government, or it could work between private citizens being an individual or a corporation. And in that sense, in order for someone who's not a native to a state, someone's not a citizen of the state, to be brought in as a defendant, you have to establish that person or entity which is being brought in as a defendant has purposefully availed themselves of the jurisdiction so that they are so they can reasonably expect to be hailed into court. Meaning, we don't want to basically say to someone, hey, you got into a fight with someone in Oklahoma, and even though you have no relationship to Oklahoma whatsoever, because this guy from Oklahoma is suing you, now you have to go defend it in Oklahoma. The only way we would do that is if there's a basis to say that you have sufficient ties to Oklahoma, and there's a number of different ways that it would take 3 law lectures.
What Joe's trying to say is the difference is between personal jurisdiction and whether federal law reaches into, in other words, whether federal law applies, the Federal Civil Rights Act, for example, applies to a certain public accommodation. In other words, Joe is making the important point that these are related issues, but they're not the same issue.
Precisely, and even venue. Yeah, thank you for putting it far more succinctly than I was.
Well, listen, walking and chewing gum is one thing. Walking and explaining the difference between, long-arm jurisdiction and the Commerce Clause.
I think when you're a professional and when you have a lot of very technical knowledge and you're very good at that and you have mastered it, it is hard to dumb down for people who are not at the same vocabulary level.
You're being too kind, Chandler. But the other point I was making is that venue is the other point I was making is that venue is not the same long-arm jurisdiction either. And that's an important thing to point out, that just because someone might be purposefully hailed in, it might be okay to be brought in there, that doesn't mean that that's actually the right state to sue them. So one could say that Twitter, for example, is, they might have purposefully availed themselves of the state of New York and had an office there, but that doesn't mean that for this cause of action, if the incidents didn't arise out of the state of New York, that perhaps venue would be deemed inappropriate in the state of New York, even in theory in general could be sued there. For that particular claim, that's not the right place to bring it. And that's the point that I was making on that.
All right, can we talk about my favorite decision or one that I really, really like that just came out about the web designer? Because I'm a web programmer and I'm getting sick of.
I don't know, you were so pissed in her dissent. Holy shit, she was pissed.
Anyway, I'm getting sick of what I feel are rigged stunts, which is the whole, I'm going to go into a business and say, you've got to go make this for me, or you've got to do this. You're going to tell me that you cannot find an LBGT web designer in this country? Oh, I'm sure you could find one that is friendly to that.
Wait, I don't know the case. Are you telling me they cake baked a web designer?
They tried to, and the Supreme Court just ruled that it's what it is. It's bullshit. And it's driving me nuts because it's the same thing as asking Joe or Ron or somebody, why don't you go build us a Yahtzee website? How's that going to go over? So I know you guys are scholars in there, but isn't this a freedom of association question?
Well, they wrote very little freedom of speech, which was nice. Not even freedom of religion, which I kind of liked for the Supreme Court. And I also liked it for a technical reason, it was a better vehicle than Masterpiece Cake because it was a pure speech case. So it didn't run into this sort of mixed with utilitarian thing. It's just the pure speech. They want to make, this is a graphics designer. They want to make wedding websites. They want to make it only for straight couples. They don't want to be forced to make speech for a speech they don't support. And it's like, okay, well, that seems pretty reasonable, and they should have their First Amendment rights. So, okay. And then Sotomayor is all like, this is the worst thing ever. But what really struck me as odd is Sotomayor doesn't either seem to appreciate or fully comprehend that if she is right, that comes back to bite her in the ass and someday. Because if the government can force this web designer to make speech they don't like, then the converse is true, right? The government could also force a web designer that she likes to make speech, right? Discrimination on the basis of religion is illegal last time I checked. So can you force some sort of LGBTQ pride friendly, and that's, you know, how they market themselves. That is their brand identifier. That is what they do. And a religious person goes to them and says, I want you to make a website for my Orthodox religious wedding. And they are forced to do that. I mean, she doesn't seem to appreciate that the door is going to hit her ass on the other way around. And I don't know why.
I have to read that. She has a really bad, like nasty dissent.
She's really pissed.
Yeah.
She's really pissed.
Didn't she just say we legalize discrimination? Wasn't that part of it?
Yeah.
They never understand that it's going to come back to bite them. They never see that, the door swinging the other way, which is weird to me, because that's the obvious, that's where you should obviously go, which is this will be used against you at some point.
Yeah.
Drunk with power. Drunk with power. I mean, I feel like a lot of government decisions, you see that, or people pull that stuff. It's like, well, I'm in power now, so I'm going to shove this thing down your throat. Well, you're not always in power, or it's not always going to work for you. And I don't know, but I'm very happy about that decision, because I'm hoping that will discourage other, and I'm calling it a stunt because I think of it as a stunt. If you go into a business and say, I know you'll find something about me or my message to be offensive, so I'm going to try to force you to do something against your will. I just think it's disgusting.
I don't know. I don't necessarily agree with that. I mean, if you have rights, you have rights, and whether or not a person walks as an innocent consumer and doesn't know any better, or
that's fine,
is purposely doing it to induce them because they have rights. I mean, if you have rights, you have rights. But of course, the First Amendment trumps that. So I don't necessarily mind someone picking a fight if they think that, you know, they're in the right, but I don't think they're in the right. So that part doesn't.
This is what her dissent said. The opinion of the court is quite literally a notice that reads, some services may be denied to same-sex couples. But I mean, on the alternative, some services may be denied to KKK members. Some services may be denied to people with nose rings. I know my dad used to kick people out of his store that had facial piercings.
No shirt, no shoes, no service.
Yeah, I mean, it's not just same-sex couples. We're talking anybody can discriminate based on random things. You have the right to serve who you want to serve, period. I mean, other than the protected categories, I guess.
Well, if you own a private company, you should be able to discriminate. You should be able to make the rules and the choices. It's not a public venue. It's not a public decision.
Unless it's life oriented. Like, let's say you're a private bridge and you say, you can't use my bridge to get to your home on the island because I don't like your kind. And that's the only path. Then I think there's an exception there.
A lot of the examples Sotomayor points to seem inopposite, because she points to, for example, hotel owners who wanted to ban people on the basis of religion. I'm like, these two examples don't really work. The hotel owner is providing a purely useful article. There's no First Amendment aspect to a hotel. You know, it's a room that you sleep in for the night. Some are more, you know, nice than others, or some are more ornate to others. But any sort of artistic aspect of the hotel is completely incidental to the hotel. It's a room that you sleep in, right? It's a utilitarian article, as opposed to a website, which is exactly the opposite of that, which has no utility in a technical sense. It is not useful. It's art. It's speech. It's not useful in a technical sense. So to combine these two things seems so far afield, because you'd be a lot closer with something like Masterpiece Cake, because now you have a blend potentially of the useful and the creative, because the cake is a useful article. It serves for the purpose of feeding people. It has calories. It's a utilitarian article. Now you're designing speech on top of it, so you're mixing speech and stuff. But to compare the hotel example, which is basically pure non-speech, to the website, which is pure speech, seems like such a weird comparison from Sotomayor.
And wasn't the cake decorator, didn't he win because he didn't deny them a cake? He actually wanted to give them a cake. He just wouldn't allow them to demand he make artistic changes to the cake.
He didn't really win so much as the Supreme Court punted. But
yeah. Well, I mean, that's why I believe that made more sense, that he was in a better position, because he didn't deny anybody a cake. So he was going to give them the cake. He just said,
he would have given them any cake off the shelf.
Yeah,
exactly. He has cakes ready to go, and he would have given them any sort of standard design cake. So if you just want a standard, cake from my catalog of cakes, I'll make you that. But I'm not going to make one that's special LGBT. Also,
because that would require him
I also
to do
noted
his
that
artwork.
I noted that Sotomayor, perhaps somewhat controversially, used the acronym LGBT. It's like, oh, where's the Q? Where's the A? Where's the two spirit and
Where's
everything
the plus?
So I'm looking forward to someone saying that Sotomayor is hateful because she's not inclusive enough. That's what I'm waiting for.
That's funny.
By the way, I have this super chat in here is addressed to Mr. Coleman. And
I've given up telling people to stop calling me Mr. Coleman. Now that I'm 60,
okay, Ron,
I gotta roll with being the dad of the right wing internet. Okay.
Oh, fair enough. And it's talking about ESG. I do want to ask you guys one question.
I hate to interrupt. I just want to note the significance to Orthodox Jews of turning 60. It is a highly significant birthday. So it's not a small thing.
It's exactly mid-age.
Oh, on your stream, I pointed it out, right?
It's exactly mid-age. It's not simply mid-age, which it is. We actually believe. Well, there are a lot of thoughts as to whether the maximum age is 120, but it's actually, as Ron pointed out on my stream, it is a significant thing.
On his birthday stream.
On my birthday stream, because he's 7 years older than me. That at 60 is when we've passed the age of what's considered that we've committed sins that would merit excommunication. So
you can't
Ron
do that anymore. So you got a freebie now.
It's basically implying that in the first 60 years he's been good. He's been sufficiently good. He's just got to hold on now for
or at least not really, really bad.
Right. Not terrible. So good job, you, Ron. Congrats. Awesome.
I did also notice that Sotomayor snuck in a reference to the Jews in there, and in her dissent. And for a while, I'm like, why does she bring up the Jews in this? In sort of like in the middle of this thing randomly? And I'm like, is she literally saying the majority is Nazis? Is that why the Jews are being mentioned in the middle of the
Jews?
Feel like a weird placement. The majority are Nazis. Theory 3 Creative is the Nazi Third Reich, I think was what she was trying to say between the lines. I was like, holy shit.
Well,
people love to do that. I mean, I saw this morning a comparison of, to Nazis for, something about like somebody very queer who was, comparing people who hate trans people to, Nazis, or it was a whole thing.
By the way, on that same note of the people who are very offended by the decision, does anybody want to place bets how many of them support Nigel Farage losing banking services?
All of them.
So I'm just saying that. Am I wrong to say that maybe there's some double standard mentalities out there, but nobody has a problem saying that PayPal can spike people's accounts or whatever because they're on the wrong side?
Those are the wrong opinions.
It only goes one way. All of this stuff only goes one way with them. They only want their way. This is why Kurt made the point they don't see the door swinging back the other way, because they truly believe they are going to be in power for the rest of eternity. And maybe that's true since they've, destroyed our voting system.
You see, and you wonder, I don't know her. Oh my God. Eric, what are you bringing in here? This is like another Nick Fuentes next to me over here. I don't know what's happening.
Oh my God. That is so unfair.
Unfair to Nick, maybe.
Fuentes.
Wow. Okay, so
You know,
on that note, I did want to have Megan on though, because I try to make it a point of anybody who's having problems with YouTube, which seems to be a constant thing. I could almost say that's a part-time
YouTube
job.
is great. They're the greatest.
Yeah, the chicanery. We call it the chicanery times, whatever. What's going on with you, Megan? Have you been naughty?
Oh, I really don't even know what I did. I honestly don't know. And YouTube doesn't know either, apparently, because I've been given 3 answers now as to why my entire channel has been demonetized. They can't make up their minds. So the entire channel, which I've had for, more than 10 years. I've had a channel where I've covered some really boring stuff like public board meetings, and I do some entertainment related stuff, Meghan and Harry stuff, and Sex in the City and Just Like That reviews. But I also have been doing short videos on Pride Month this month, and I call it Cringe Month. It's been just looking at the worst of Cringe Month. I have not targeted anyone specifically, just the ideology itself of, shaking your naked junk in front of kids, I think is a bad idea. And I guess you're not allowed to say that on YouTube anymore. I have deleted like so many videos that I think, well, maybe it's this one, maybe it's that one, because they won't tell you. And the first thing they told me was that it was demonetized for harassment and bullying.
Of who?
They won't tell me. I guess I bullied the month of June, Pride Month, I guess. I guess I bullied the month of June is what I'm going with. Pride Month feels very harassed by me. But then the second explanation I got from Google in an email after I started my appeal, which they still won't verify if they got, said it was for hate speech. They said vast quantities of my content contains hate speech. So I went through and I deleted like all my live streams except for the Johnny Depp trial.
That's their way of saying it's you, Megan.
I know. And then
It's
the
you.
third explanation I got today on Twitter from Team YouTube was, we've reviewed your account and we have found that that vast majorities of your content contains sensitive content. So now we're on the third explanation. I don't even know what sensitive content is.
Hemorrhoids.
I assure you there's none of that on my channel. But
On that note,
They don't
I
like
have to interview Michael Malice for my podcast, so I will
Oh.
bid you all
Nice.
adieu.
Congrats.
Listen, the algorithm does not love Ron Coleman, but Michael Malice always helps.
Oh,
Have a
yeah.
good one,
Good luck.
everybody.
And
Take care.
look forward to it.
bye, Ron.
See you. Congrats.
So I don't know what I did. And I'm never going to know because they're not going to tell me. And that's how they get rid of you. And there has been a target on me from YouTube for a long time. I've been shadow banned for a long time. And they started messing with my channel. I had a warning in place. And then I got 2 strikes back to back on old live streams that I did from months and months ago. But I beat both of them. I beat both strikes. They removed both strikes. And then, but that was when I decided, I talked to Nick about it a bit, and he was like, you know what, stop live streaming on that channel, just live stream on Rumble and just do short videos, short video clips. So I've been doing these short video clips of just news articles, reading news articles, giving my opinion on them in 5 minutes or less. And then suddenly demonetized. And there were only 3 videos that I didn't win my battle to remonetize, and I deleted all 3, and they're still saying that my channel can't come back. The monetization can't come back. I think it's very interesting though that this happened right when Glad put out a notice to YouTube and Instagram and some other social media platform, I don't remember which one, telling them to get rid of anyone who is advocating for hate speech against the trans community in particular. And I've been very vocally, against trans ideology. I think it's bad for kids. I think it's bad for humanity in general. And I guess you're not allowed to say that, but this is nuts. It's just nuts.
It happened to Candace Owens as well. And I can't help but picture some pink-haired angry person on the other end of that computer screen, going, report, report, report. Somebody who works for YouTube, perhaps. I think it's egregious.
Yeah, I think that it's somebody doing this because how then do I win the appeals on the videos themselves that they deemed not advertiser friendly, and I don't get strikes for any of these things, and I have no strikes on my account, but I wake up one day and the whole thing's demonetized. How did they do that? And they won't give me an explanation.
Well, one thing you've got it. Yeah, I was gonna say, Let's Go Brandon's right, and it's one of the sad things about YouTube is working within YouTube and YouTube Studios and appealing is a giant joke. You quite literally have to go to Twitter to get YouTube to do anything. And you've got to get enough people beating up on Team YouTube, or knocking on their door saying, "Hey."
Well, I would appreciate it if you guys would do that. I mean, they do respond on Twitter, but so far they've responded to say, "We've reviewed your entire channel, and now you have sensitive content there." Oh, you reviewed 1,000 videos in the last 24 hours? No, you didn't. You're a fucking liar. People are liars. They're not reviewing shit. There's no sensitive content on my channel. I don't show. I only had one live stream, which I probably deleted at this point, that had me and Andrew Branca reviewing one shooting video. That's the only time I've ever had anything that could be considered sensitive content, and I didn't get flagged for it. So I can't think of what else is sensitive content other than violence, right? Isn't that what sensitive content? They're always accusing me, though, of harassing and bullying people and harming people. And it's like, harming people? I'm talking about ideologies. How do you harm people by going at ideologies?
Maybe you were harming the feels of the people on that school board.
Yeah, the school board. I mean, the majority of my videos are boring as hell. Like, let's just be totally honest. Like, I talk about school boards and FOIA requests.
This is how you get new subs. The majority of my videos are boring as hell. Please subs today.
Right. Sub to my channel. Be bored with me. I don't know. I don't get it. I don't get it.
Next week, she's going to feature a 4-hour educational documentary on the lifespan of the African moth. Make sure you tune in and watch as it rises slowly from larva into.
Because sensitive content means that they just don't like it and they don't have to explain it.
Well, it could be individuals too. I mean, if you are, you wrote for PJ Media or whatever, you could have some actors who are just continuously reporting you in the back end at YouTube. I've sometimes wondered about that, because you could have just dedicated people and their function in life is to
happening. Shouldn't they see that when they review it? Like, shouldn't they see that there's a red flag? Like, I think the biggest red flag is that I don't have any strikes. And reading through the rules, it doesn't seem like they can demonetize an entire channel without any strikes.
Yeah, they can. Or they do. I mean,
or they do, but it doesn't say that in the rules. The rules say that you get the strikes and then these things will happen. So I don't know.
Kurt, that would be a good question for all the lawyers. I guess it's a YouTube partner program. And they can just say, we don't want to be a partner. I don't know. Maybe I'm wrong.
I mean, YouTube service gives them a lot of discretion, as you would appreciate, to kind of do what they want. And their lack of consistency hasn't been a problem. People have tried suing them for breach of contract, suing them for bad faith and things like that, and those have not been really successful as of late. There was one that actually kind of went somewhere on the federal system that I was following that kind of went somewhere. So, but most of them don't go anywhere. So
I do remember you talking about that one a little bit.
Yeah, I don't know. I could pull it up in Court Listener and see where that's pending. Give me a second.
Yeah, because that's really what
I have it flagged.
Yeah, everybody's like, sue YouTube. It's like, sue Google. Are you crazy? Okay, give me the $1 million or $2 million that I need to do that, for one. And it would probably even be more than that. And I just don't even, that's just not even an option. I mean, you can't sue.
I think you have better odds of trying to go through like a state's attorneys generals and things like that to try to go after YouTube than you personally, if you could, or am I wrong? I mean, where they could say that YouTube's
theory
messing with their citizens or something like that. I don't know.
Yeah, like Texas sued Netflix or filed against Netflix for that one movie and stuff. You could maybe, if you're in the right jurisdiction.
They did. Actually, I remember that. I was talking about that.
Well, yeah, they're still going. As of August the 1st, the court ordered there was a motion to dismiss from Google and they denied it. So it's still pressing. So I imagine there is some sort of discovery as of now. This is Schneider versus YouTube versus Google. Give me a second. Schneider versus YouTube in the Northern District of California. I'll give you the link for it in the private chat if you want to follow.
Yeah, I don't remember the underlying facts. I just knew there was something still pending.
So Fat Slice in the comments said, I suspect that it's Megan Fox's Pride celebration video that is sensitive content. They probably consider it demeaning toward a group. Okay, here's the thing though. They said that video was not advertiser friendly. I fought it and they reversed their decision.
Wow.
So how could it be that video? It can't be.
I think they have different yardsticks on that. I mean, I remember even going back like 2 years before he grew out the hair, Viva did a video once where he was talking about how he had a video that was marked not suitable for advertisers. He appealed it. It went green and then it went red. And when he appealed it going red, they're like, no, now it's red. So they literally will just flip flop in ways.
But I didn't get a notice hitting it again. Like they
No,
said,
they just do it. I had that happen with the Nate and Eric channel. It's the only channel I have that has anything on it. I have a warning because I don't know if you remember the bus incident with the driver who struck a passenger or whatever. And that video is everywhere because part of my complaining was that they age restricted it. And I appealed that, and then they removed it and gave a warning on the channel. And I'm like, here's 10 other copies on YouTube right now that are perfectly fine. And they said, thank you, have a nice day. And that was Team YouTube as well. And I'm still pissed off about it, to this point.
Yeah,
But
I feel
it's
you.
very strange how they look. I would be fine if they said these several videos are not in line with our terms of service and I could just, delete them and start over or whatever. So I would know what it is they're talking about. But instead of doing that, they say, go and read this article and then you go and clean up your channel on anything that I've read the articles. And I'm like, well, I haven't done that. I haven't done that. I haven't done that. I don't know what they're talking about.
Well,
And
Megan,
so-
I'm going to point out to you one thing you should remember, and that every YouTube content creator should remember, specifically about what Eric was just describing, is YouTube's motto is rules for them because they're MSM.
Okay.
There are special rules for bigger channels than ours. And MSM, I'll include in that Daily Wire, and there's certain channels that they can
look at
post
Blair
content.
White.
And
Blair
if we
White has-
copy their content, we will
Blair
get
White-
we'll get a strike for it.
Blair
I
White
steal,
has a
man?
huge channel, way bigger than mine. The things that she says about trans people are way worse than anything I've ever said. And her channel's still fine. Like,
well,
why?
she is trans. She's
That's
protected
why.
I wonder if
class.
that
Yeah.
has something to do with it. But I feel like
But
she
I-
gets a lot of flack. So, I agree, Megan. I think that there's a comparison there for sure. It's because her channel is much larger, probably.
Hmm.
Okay, so this is another idea, I guess, starting over again with another channel. But oh god, I mean,
That's
That's a
rough.
pain in the ass.
And
That's a
also
lot of work to
Rumble.
redo.
Everybody will say, just do it on
go
Rumble.
to Rumble. I'm on Rumble. I've been on
And the-
Rumble for over a year. I can't
the
make any
money's
money
not there.
Okay, it's
No.
just not there. So YouTube actually pays me, not a whole lot. I make very little on YouTube, but the very little I make, it's like, but it's mine. I made it. I want it.
You
And
shouldn't
it's
have
my
to move to
channel.
Rumble. You shouldn't have to move to Rumble. There's no. I mean, you put out good content. There's no reason for you to have to be censored, to have to move over there. I mean, you've done nothing wrong.
I
Right,
also
I don't
wanna
think
point
I've
out-
done anything wrong. I've done nothing that other creators are not doing that I see them doing all the time. Like,
Listen, I mean, I've watched your content, and I'm probably the only person on this panel who's one of those letters. And like, I'm not offended by anything that you say. I think that you say a lot of really important things that need to be heard. I always like hearing your perspective because I think that you speak out, for people who are concerned about children, and a lot of people like Gays Against Groomers, for example, who I really
My
admire
friends.
and appreciate. Yeah.
And Chandler,
Jamie
I'm going to
Mitchell.
point out the reason why everyone likes you is because seriously, I had no idea that you were a letter until you just said it now.
I didn't know that
I
either.
don't give the slightest darn about it. But what's very, very cool about you is that I did not know.
Yeah,
You didn't
that I
make
didn't
it
know.
something that everyone has to know. No one has to know anything about your personal life. It's not my
Right.
business, the world's business, or anyone's business. And rather than making a statement about this is who I am, which is the way we've seen,
I know Chandler
streamers go.
as a legal commentator. I don't know as
Yeah, who the
one
heck
of the
knew that?
letters
I
on
have
the
no
Because
alphabet.
because it doesn't matter. It's not intrinsic to
Exactly.
anything about me professionally or the way I present myself. I mean, I like talking about my life and things that are, I don't like only do legal commentary, but it's just not relevant or important. So thank you,
Right.
Joe.
Well,
But you have
that.
upset the chat now.
No chance for Chandler.
I said I'm one of the
Well,
letters. I didn't say which
yeah.
letter.
She
Yeah,
didn't
there
say
you
which
go.
one. The B's could go
At least
either
one.
way.
At least one letter.
All a good point. I don't know. The chat jumped to a conclusion, but no, I want to clear up something about Rumble really quickly because we hear it a lot. You complain about YouTube and you don't do Rumble. Well, I'm on Rumble, and I will tell you because I know several of the people. All of the creators who make money on Rumble are under a contract by Rumble directly.
Yep.
There is no way, and I'll name Nick Rekieta because he's come out very publicly and stated it. When he went over there, he would have 5 times the number of views, everything else, and he's like a quarter of the money, a tenth of the money. This is a reality. There's so many issues, and I want them to, get there, and they will, but they still don't have Rumble rants on your phone, for God's sake. They've been talking about going out there and on and on.
There's also a problem on Rumble that the people aren't there. Okay, I built my YouTube channel up to almost 20,000 subscribers. That's I know it's still small, but to me, that's a big number. And on Rumble, I'm at 4.47 thousand followers on Rumble. Okay, it does not translate. The audiences do not translate from YouTube to Rumble, and Rumble's never going to offer me a contract with 4,000 followers.
It's much more than that. I think it's safe to say that there is no human on the planet as of today, June 30th, 2023, who has made enough money in a year from Rumble that they could live on that money unless they've gotten a contract from Rumble. And that being the case, as opposed to YouTube, which there are literally tens of thousands of people who never had and never will have a contract with YouTube, who are able to make a very healthy living just by working on YouTube. So when people say just move to Rumble, that's okay. That's a great idea. Many of us, myself included, Uncivil, Megan, I think all of us are on Rumble. But
this is on Rumble right now. This is live on Rumble.
No human could survive off of the income they make from Rumble unless they're under contract with them when they get a specific payment from Rumble. As of today, hopefully, 6 months from now, that's changed dramatically, and every one of us can look to Rumble as being a primary source of income. But
I'm going to consider myself a part-time YouTuber because I do have a full-time job. And it is so difficult to line up a live stream that goes YouTube and Rumble at the same time. You can only do it 24 hours in advance. You can't line up 2 live streams at the same time. At least on my account, I can't do that. I don't know. I have so many issues.
You should be able to.
You don't need to do it 24 hours in advance.
Yeah, I don't. I did this one this morning.
No. You can't do it beyond 24 hours in advance. And you can't do more than one live stream at a time.
That's true.
When I have like today,
both are true. Even on different channels, I have multiple channels.
I have 3 streams today. I can only program one, and then I have to think about it, and then I have to manually set it up and go through all the steps, and then link it to StreamYard, and then that's the problem for me. I don't have the time.
There are problems that they need to work through, but look, YouTube has actually been a place where I've been able to make great money at when the thing spikes, when you get the spike up in interest, like for instance, during the Johnny Depp trial, I covered that trial, made great money. Now there's not even the possibility of they've just completely taken it away and without any explanation. And the reason I feel like I'm so pissed about this is because it's so unfair. I've literally not done anything that I haven't seen other creators doing every day that they're still doing right now. I'm somebody who really does watch what I say. I don't use slurs. I don't target people by name. I don't get into YouTube flame wars. It's very, very, very rare that I will name someone and go after them who's like another creator, which is one of the things that in the harassment bullying thing is about. But I know that there are channels that are dedicated to doing this. That's all they do is go after other creators, and it's totally against their terms of service, and yet they're out there and they're not demonetized.
Drama channels, sure.
Yeah, the drama channels. Yeah, and clip channels, and that's all they do. So I don't know how this is just not okay. It's just not okay. So if you guys want to help out there, please tweet at Team YouTube and try and get I've got a bunch of stuff posted on my profile. I'm at Megan Fox Writer. I'm trying to get them to give me at least an explanation that I would like to know what it is that I did.
Contact Reclaim the Net as well. You probably get coverage, and I mean, you are a journalist. You're kind of connected. You might be able to get your story out there a little bit.
Yeah, I haven't written about it yet.
You should. I mean, because then you can point to that, and that can amplify even better.
And
or you could take an acting class, change your Twitter name to Megan Fox Actress, and you'll probably get all of a sudden like 10 times as many retweets.
AI. Just do AI. No.
It's so bad. It's so bad that I just feel like, and it's not just me that this is happening to. It's happening to a bunch of people all at the same time. Was it Parker Posey? Or I never know what her real name is. I always forget. But the woman who's in England, and she has got that channel where she talks about, women's rights, and she's, against the trans ideology. She was demonetized the same week I was. So I really do think that it was the GLAAD push to have us shut down anyone talking out against the trans agenda in particular is not going to be allowed at all on YouTube.
I'm certain that that's what it's about, because I've seen it happen over and over. With Candace Owens, she had to remove all of her previous videos where she had even discussed trans issues, which I'm sure was a lot of videos. And but she has the Daily Wire backing her. It's different, it's more streamlined. And then I even saw somebody who is trans themselves, and they have the offensive tranny, as their name, and YouTube deleted their account for that reason. So there are problems with that, and I'm sure that because you comment on that, that's why they're censoring you. But I personally really enjoy your voice. I love your videos. I think you have something very important to say, and I want you to stay on YouTube, and I want you to be able to keep making content and putting it out on YouTube. So for everybody out there who has a Twitter, please tweet at Team YouTube and, retweet Megan, because this is an important issue that we need to address.
Bye, Joe.
Joe's out. He's like, I can't be next to her anymore.
I guess. I mean, I can't even cut him off now.
We're not going to get a rant?
The show's over.
We're not going to get a rant. Oh, no. What are we
I
going to do?
can't cut him off at the end. It's like, what do we do? I have to just keep the show going all day forever because I'm not here to kill it.
If you want, I'll just start talking endlessly about the Supreme Court. You can cut me off.
I like that idea. Let's do that.
Actually, I guess I am planning to wrap up now anyway. But Chandler, where can people find you?
People can find me at Remy Legal, REMY_legal. I'm going to be doing a stream tonight with MLS Law, Solomon Anderson, and Legal Vices at 8 p.m. And we are going to be talking. Yeah, I loved
8 p.m.
your
Eastern.
Yes, 8 p.m. Eastern. I loved your video with Solomon, Megan. I watched it before. I kind of in between interviews with Solomon. I've been talking to him.
Interview.
We are going to be discussing next steps for Zachariah Anderson, and we have been co-authoring with Natalie Wisco a letter to the Wisconsin Attorney General, as well as other letters to other authorities in the Wisconsin government to work on Zach's appeal.
I'm going to watch that.
Not from a legal perspective. Obviously, we can't do the appeal for him, but yeah, we're excited
great.
about it.
All right, Dave. I think Dave is getting closer to a milestone. He's really trying to hit 2,000.
2,000 by the 4th. That's the plan. 2,000.
So there's 1,559 people in here, and he needs less than 200. Maybe we can help him out. You can just click on his name in the description. Actually, you can click on everybody's name in the description and subscribe to any of them. I'm just pointing it out because it's always great to pass these thresholds. We got Chandler actually over 1,000 on this show a few weeks back. And I just love it when, channels can grow out of here. So
thanks for having me on. It is MLS Law Show. There we go. MLS Law Show. Right now we are streaming currently the Texas Border Patrol mistress murder case. And that's what we got going on. And then tonight, obviously with Chandler, Jeff from Legal Vices, Solomon, and myself, we're all streaming. And I think we're triple streaming. So it's on Chandler's stream as well as Legal Vices and myself. We're just trying to get the word out there. So check that out this evening. And then every Tuesday and Saturday at noon Eastern, 6 p.m. Swedish time, we cover the Jodi Arias trial. No matter what we're doing, we stop and we do Jodi Arias for a couple of hours. Usually on Saturdays, it's a longer stream, which has been a lot of fun. We're day 6 now, and we're getting into the photos. So if you want to see the photos, that's this Saturday at noon Eastern.
Ew, yeah, kind of disturbing. Kurt, what do you have going on?
Yeah, so I'm on civil law. I've been covering a lot of U.S. Supreme Court case recently because, of course, June is the month for all the big decisions. So we've been covering that. And normally on weekdays, I do a legal news review in the mornings, usually about 9 o'clock Central Time, 10 Eastern, where we cover that news stories that are in the news and try to cover some good stuff, Court of Appeals, try to keep things interesting, some true crime. Recently did the Scott Peterson trial out of Florida. That was pretty interesting. Pleasantly surprised by the verdict. Pleasantly surprised by the verdict. I thought they would convict him of something, but no, they didn't. And yeah, just try to give, and I'll be covering probably the suitcase murder trial coming up with Legal Vices. We've tentatively agreed to cover that together. So looking forward to that.
Awesome. Now, Megan. Megan promises her content really isn't boring. So you can click her name in the description and subscribe. It's was it Megan Fox Writer? At Megan Fox Writer, and again, you swear that it's not boring, right?
I swear that it's not that boring. What I don't understand is how YouTube looks at a bunch of these videos of mine, which is like public boards, public board meetings, which are boring. I make them unboring because we like to mock the people who come up and try to defend porn in schools for kids, But other than that, I mean, lately I've been doing entertainment stuff. So I'm covering And Just Like That second season, which is the worst show on television. And I've decided that I am going to do it. I'm doing it on Locals, and I'm doing like teaser videos on YouTube that are very short, and the full videos are being posted to my Locals, meganfox.locals.com. And guess what? Next week, the trial of Gerson Fuentes is coming up in Ohio. He's the illegal alien who raped the 10-year-old who was trafficked across state lines for an abortion by abortionist Caitlin Bernard. That is coming up next week. Supposedly it has been put off twice now, and I am following that. I will be reporting on that if we can get cameras in the courtroom. Salem Media has been trying very hard to get cameras in the courtroom. We have one reporter who's been given access, and we think she's going to get web access, but we don't know yet. We're waiting to find out what that actually means. So that's going to be interesting, but I am definitely going to be paying attention to that and reporting on that as well.
By the way, I'm glad you mentioned Locals. Obviously, I just did a little scroll. I'm on Locals. While I complain about Rumble and how much you can earn or whatever, Locals is excellent. So Rumble, not so great, but Locals has been incredibly important for me as a creator, and I can't say enough good about it. Like, literally 50% of my income or more is because of Locals and people directly supporting them. I always want to, give credit where it's due. And then we always try to close out with Joe, find out whatever's going on with him. And then Joe's Joe, and he always has some form of wisdom that he is going to share at the end to take us out. So Joe.
Hey, I'm Good Lawgic. You can find me on Locals at Good Lawgic. I am a nature survivalist. I cover all sorts of things about how you can drink from soda from trees out in the wild and which berries are poisonous. So make sure you follow me on goodlogic.locals.com. I actually have a promo going on now that if you sign up for the first month and sign up monthly, it's better to do it from a browser, not from the app on Locals. Use promo code KEEPMEJOE, KEEPMEJOE for the next week. You can get a month free. Try it out. You're going to love it. Goodlogic.locals.com. All jokes aside, I'm going to be tweeting out on Twitter. I'm at The Following Pro. I'm going to be tweeting out a whole bunch of stuff about Megan. As much as I poke her and literally enjoy poking, she's a phenomenal human being, great content creator. The stuff is really like scale of 1 to 10, how like 1 being really fascinating and 10 being like crazy boring. She's like 6, solid, like really amazing. So what more could you
solid 6?
want?
Well, you know, I'm medium good, Joe. It's my
No,
it is I'm medium smart. I'm medium. We
Right.
we don't strive for perfection here.
Right.
Medium good is good enough. I'll take a
Great,
6.
phenomenal. She's great. Are you kidding me? Amazing. So yeah, so everyone should follow her. But like, you know, as far as like final thoughts, I didn't really get to weigh in. The important thing we should all take as Americans from the decision coming out from the Supreme Court today or yesterday, the most important thing that we